just like we like to see, sanctions against Donald Trump and parking lot lawyer extraordinaire Alina Habba. Now, we're going to take a little bit of a trip down memory lane, but trust me, it's worth it, because the 11th Circuit Court of Appeals has just affirmed a federal district court judge's ruling that sanctioned Alina Habba as well as Donald Trump to the tune of $1 million in attorneys' fees and costs that they have to pay. You gotta love it. So let's pull up this order. It's worth it. November 26, 2025, 11th Circuit Court of Appeals, as I noted, in its several appeals that had been taken by Donald Trump and Alina Habba. It was before a 3-judge panel led by Chief Judge William Pryor, Judges Brasher and Kidd, and we'll get into who they are in a second. But it's a 36-page order that you're seeing in front of you, and it was consolidated appeals, which means that there were 4 different appeals taken from the district court judge, Judge Middlebrook's multiple rulings, and they were consolidated, meaning they were put together for purposes of the 11th Circuit to hear them on an appeal. And what did the district court judge do? Well, Judge Middlebrooks dismissed Donald Trump's lawsuit that he brought against several defendants, and we'll get into who they are in a second. Judge Middlebrooks dismissed Trump's amended complaint with prejudice, and as all of you have learned here, when something is dismissed with prejudice, it cannot be revived, it cannot be brought back unless an appeals court tells you otherwise. For failure to state a claim, meaning that Donald Trump amended his lawsuit against these defendants and could not get his shit together, courtesy of Alina Habba and other lawyers in Florida, to be able to get across the finish line of even just the basic allegations in the complaint. The defendants moved to dismiss, and the defendants moved for sanctions. Judge Middlebrooks entered sanctions against Trump and his lawyers under Federal Rule of Civil Procedure 11 and under the court's inherent authority to sanction litigants and lawyers. While those orders from Judge Middlebrooks were up on appeal, Trump and his lawyers moved the same judge, Judge Middlebrooks, to reconsider each of the orders that he had entered in light of special counsel John Durham's report that had been issued. Those defendants also moved to disqualify Judge Middlebrooks. The judge denied both of those motions, the special counsel John Durham one and the motion to disqualify. 2 of the defendants asked this appeals court to also sanction Trump for bringing a frivolous appeal on those 5 orders. This is what the 11th Circuit says, quote, because Trump and his attorneys committed sanctionable conduct and forfeited their procedural objections, we affirm both sanctions orders. Wow. Okay. So here's the background. Trump alleged in an amended complaint that in the lead up to the 2016 presidential election, Hillary Rodham Clinton, who he sued in this lawsuit, and this is in a federal court in Florida. Hillary Rodham Clinton, the presumptive presidential nominee for the Democratic Party, conspired with others to weave a false narrative about him. Clinton and her allies sought to discredit, delegitimize, and defame Trump by fabricating a story that he and his campaign colluded with Russia. Now that's what Trump alleges. We all know what the truth is. But so some of the defendants in this lawsuit were Hillary Rodham Clinton, the law firm Perkins Coie, Mark Elias, our good friend who was a partner at the time at Perkins Coie, Fusion GPS, Orbis Limited, a private intelligence firm run by a guy by the name of Christopher Steele, Igor Dachenko, a Russian analyst, Charles Dolan, a political operative with ties to the Clinton campaign, Perkins Coie partner Michael Sussman. I mean, there's all these people, right? And so Trump pretty much sued a whole lot of damn people. Anyway, what ends up happening is this. Trump, of course, as we know, alleges that this conspiracy is still ongoing, as we have seen him allege, and as you've seen him try to task the DOJ to be able to do something about it. Trump alleges that he suffered at least $24 million in defense costs and legal fees because of the conspirators' actions, in addition to loss of business opportunities. So that was the crux of the lawsuit that he brought here in Florida in federal court. He alleged 16 claims in his amended complaint. So there were 28 named defendants that were identified in Trump's lawsuit as of March 24th of 2022. Trump's initial complaint was 108 pages long, had 508 numbered paragraphs. There were two law firms that were representing Trump, Alina Habba's law firm and this law firm in Florida called the Ticktin Law Group. The guy that the law firm is named after, Peter Ticktin, he's like asshole buddies with Donald Trump. Judge Donald Middlebrooks was assigned this case in federal court. After he was assigned, and remember, it's a random lottery assignment in federal court, as it is in state court, Trump moved to disqualify Judge Middlebrooks on the following grounds. And you're going to love this because what's good for the goose is good for the gander is what I think with somebody like Trump. But listen to this. Trump argued that the reason why Judge Middlebrooks must be removed from his lawsuit was because Middlebrooks had a, quote, relationship to the defendant Hillary Clinton because President William Clinton, Bill Clinton, had nominated Judge Middlebrooks to his position. Okay, if that's your rationale, then any Trump-nominated judge should never preside on a Trump-related case, which would also suggest that people sitting on the fucking Supreme Court shouldn't be listening to stuff that deal with Trump. Judge Middlebrooks appropriately, legally, and smartly denied the motion to disqualify. Warnings were provided by some of the defendants to Habba and Trump, basically saying, you are filing things in bad faith, you are being frivolous, your facts are dead ass wrong, please fix it, please remove us. In the end, Trump, Habba, et al. Refused to do it. So there was an initial round of motions to dismiss by the defendants. Trump filed an amended complaint to try to cure the defects that had existed. He didn't take away, right? He added over 80 pages of allegations and then he tacked on 3 more defendants. So Habba, being the dumbass that she is, doesn't try to fix the problems that happened before. She just makes them worse. How? By adding 80 more pages of allegations and adding 3 more defendants. So now we got 31 freaking defendants, right? The 4 attorneys that are on this amended complaint, Alina Habba and Michael Madeo from the law firm of Habba Madeo, and Peter Ticktin and Jamie Allen Sasson, S-A-S-S-O-N, from the Ticktin Law Group. Think of them when you think of quality lawyers. Judge Middlebrooks dismisses the amended complaint, saying not only was that lawsuit, quote, foreclosed by existing precedent, and implausible because it lacked any specific allegations which might provide factual support for the conclusions reached, he also found that Trump's amended complaint misrepresented its sources. It also was what we call in the law a shotgun pleading, meaning not only was it excessive in length, but it also tried to shoehorn preceding paragraphs of allegations into counts as well as those preceding counts into subsequent counts. And so it pretty much made it almost impossible to discern what were the allegations that were relating to specific counts, to specific defendants, etc. On the merits, Judge Middlebrooks found that Trump's claims failed as a matter of law. And the judge said, you know what? I'm not even going to let you try to amend again because not only is it going to be futile, but it just doesn't make sense to waste any more time. That's how bad you are, Trump and Habba and Ticktin and all you other lawyers. So the court reserved jurisdiction to adjudicate issues that were pertaining to sanctions. So after Judge Middlebrooks dismisses the amended complaint, one of the defendants who had basically served Rule 11 sanctions warning said, pursuant to Rule 11 of the Federal Rules of Civil Procedure, I'm now seeking sanctions against you. That particular defendant, Dolan, asked that Trump's attorneys pay a $50,000 penalty or fine plus $16,274.23 in fees because of their willful conduct. Okay, that's it. Following Dolan's motion for sanctions, many of the other defendants jointly moved for sanctions against Trump and his lawyers. Judge Middlebrooks granted those motions for sanctions, describing not only the shotgun pleadings that you and I just talked about, but that there were knowingly false factual allegations made, frivolous legal theories asserted, as evidence of the bad faith of Trump and the lawyers. Judge Middlebrooks also mentioned that Trump had a history and a pattern of filing frivolous lawsuits, and that pattern of misusing the courts was also a basis for sanctions in this case. Judge Middlebrooks calculated that the fees and costs that were owed to multiple defendants totaled $1 million. $1 million. Judge Middlebrooks allowed Trump to be able to raise objections to the fees and the costs that were asserted by the defense attorneys in this case. And in the end, the total ended up being $937,989.39. Judge Middlebrooks found Donald Trump and Alina Habba, along with Habba's law firm, jointly and severally liable for that almost $1 million. So let's take a second and talk about what joint and several liability is. This is what it means. It means that the judge said, this almost $1 million, you are all collectively responsible for it. I don't give a shit who ponies up the money and how you want to divvy it up amongst the three of you, because remember, it was Trump, Habba, and Habba's law firm. But the money has to be paid. Again, don't care how y'all do it, but y'all are jointly and severally liable. So it's not like Habba could say, Trump, this is all your fault. You got to do it. It's not like Trump could say, Habba, you suck, which we all know, or your law firm sucks. You guys have to do it. Judge says, I don't give a shit. The money has to be paid. Keep that in mind, right? Alrighty. So I'm going to fast forward and basically say the following. The appeals court considered all of the arguments that were raised by Trump and the other Trump and Habba, and basically says, look, we don't think that Judge Middlebrooks abused his discretion when he entered sanctions against Trump and Habba. And basically, not only was it based upon the court's inherent authority to be able to do that, but also the Rule 11 sanctions that were raised also justified the sanctions in this case. We also don't find that Judge Middlebrooks erred as a matter of law, committed any error when he found as a matter of law that Trump's racketeering claims that he raised in his lawsuit, that they did not actually make it across the finish line. One of the most scathing things that this appeals court found was that Alina Habba / Trump, her client, failed to preserve arguments on appeal. So what happens is this: when you are on a lower court level and you fail to object in a way or raise grounds for objections to things that are happening, they are considered to not be a part of the appeal because you had the obligation to do them. And the appeals court in this opinion makes it very clear that Trump and Habba abandoned arguments by not raising them in the district court despite having the opportunity to do so. Quote, we do not consider issues not presented in the first instance to the trial court. And so Trump and Habba tried to raise all the stuff on the appeals level with the 11th Circuit. And the 11th Circuit is like, you snooze, you lose. You don't raise that shit at the trial court. Don't come running to us to be able to fix that problem. And what is that a clear reflection of? It's a reflection of how shitty a lawyer Alina Habba is, that she did not know that she must preserve these issues for purposes of appeal. And in the end, the appeals court said, look, I'm also finding, or these three judges said, look, we're also finding that Judge Middlebrooks was allowed to bolster his finding of bad faith by pointing to Trump's litigation conduct in other cases. That pattern of misusing the courts was certainly relevant to the court's argument here. Finally, the appeals court says, look, that $1 million, that's actually an appropriate amount of money, and we don't take any issue with Judge Middlebrooks' calculation of it. I mean, look, sometimes the good guys win in this case. And Trump has taken this appeal, and an 11th Circuit panel of judges has said, you know what? We're going to sustain what Judge Middlebrooks found, more or less, like 99% of what Judge Middlebrooks found and did. The stuff with which the appeals court disagreed with Judge Middlebrooks was so minor, it actually didn't even rise to the level of anything worth noting in this episode. And remember how I told you that I was going to mention a little bit about these three judges that are on the 11th Circuit, these justices? Well, look, the chief judge, Judge Pryor, that's a George W. Bush appointee. That's a Republican there for you. Now, Judge Kidd is a Biden appointee, but get this, Judge Brasher, Trump appointee. So Trump argues that Judge Middlebrooks has to be disqualified because Bill Clinton nominated Judge Middlebrooks. Huh, isn't that interesting? Wouldn't that be an interesting argument for people to be making? I mean, look, when you have all three of these 11th Circuit judges finding that there's no error that was committed here and that everything was appropriate in terms of sanctions, I mean, it's the right thing. It's not only the right ruling, but it's the right thing to find. So celebrate the wins. As I've said to you here, I think it's a great win. $1 million freaking in sanctions for fees and costs that Trump and Alina Habba have to deal with together. Isn't it lovely?
Remember I tell you that we have to celebrate our wins when we get them? Well, not quite at the win stage yet for this, but I consider it to be a win for the rule of law. Remember those Venezuelans that were flown to El Salvador's CCOT prison over the objection and in defiance of the court order by federal Judge James Boasberg? One of those detainees that was illegally and unlawfully removed from United States soil is a gentleman by the name of Neyerver Adrian Leon Rengel. He is a Venezuelan, and he was a part of those dozens of people that were sent to El Salvador to be just forcibly put into CCOT and held against his will for more than 4 months. What has he done? Well, he is the first of these Venezuelan detainees that has initiated the process, the legal process, to be able to sue the United States government for the illegal treatment and harm that he sustained because of our federal government. And so I want to walk through what has happened so far so that you understand why, again, I consider this to be a win for the rule of law, because this is how we're supposed to do this. We can't always right all the wrongs, but when there is a pathway that is provided for relief, we should take any and all opportunities to be able to pursue those, because there are judges out there that are showing, like James Boasberg, that they are going to do the right thing. So I am proud, and again, this is in the interest of full disclosure and transparency, I am proud to say that Democracy Defenders Fund, of which I am affiliated, it is Norm Eisen's group that he launched, and I am proud that I am a part of Democracy Defenders Fund. And Democracy Defenders Fund is representing Mr. Rengel in his claim against the Department of Homeland Security. So when you are suing the Department of Homeland Security, as it is a federal agency, you have to sue under a specific federal statute. It's called the Federal Tort Claims Act. And basically, it's a way by which normally you couldn't, right, seek recourse. But in this instance, if somebody who is an employee or an agent of the federal government acting within the scope of their official duties does harm to you, you can sue under the FTCA, the Federal Tort Claims Act. So in this instance, Mr. Rengel is alleging that Department of Homeland Security, Immigration, Customs and Enforcement, and the Department of Justice, as well as the State Department, that they violated his rights, that they caused him emotional and psychological harm because of his unlawful detention, removal, and mistreatment. He seeks $1.3 million in damages for the harm. I think that's undershooting the runway, but I do think it's a reasonable way to be able to present your claim. His claim alleges negligence, malicious prosecution, abusive process, and false arrest. Let's walk through the claim so you understand exactly what is at stake. Under the FTCA, in order to be able to file a formal lawsuit, you have to initiate litigation by way of an administrative claim. And you file a claim for damage, injury, or death with a specific form. And the form must be submitted to the appropriate federal agency to whom you are directing your grievances or your complaints. In this instance, this is going to the Office of the General Counsel for the Department of Homeland Security. And Mr. Rengel attaches a very detailed statement of his claim to his form. Now, what happens is once this claim is made, the federal government has a 6-month window to be able to do the following. The federal government agency can accept the claim for Mr. Rengel and settle it with him. They can deny the claim, at which point in time, Mr. Rengel can then initiate his formal lawsuit. Or Department of Homeland Security, federal government can do nothing. And in doing nothing after the expiration of the 6 months, again, Mr. Rengel can then pursue his litigation. But you should read this attachment because it really lays out, and again, this is just one man's horrific journey, but it really lays out in detail and firsthand. Like, you know, we've been talking so much about Kilmar Abrego Garcia, Mr. Rengel, and others, but to hear it from him, to describe what happened to him and the firsthand experience, It's one of the more unique kind of insights that's being provided here. So Mr. Rangel says that he was detained and removed from the United States without cause or due process. Federal officials lied to Rangel, telling him he was being sent to his country of origin, Venezuela. Instead, for 4 months, he languished in El Salvador, which is not his country of origin, and a place where he has no ties, where he suffered physical, verbal, and psychological abuse. Rangel is from Venezuela, and he entered the United States in 2023 at the Paso del Norte port of entry in El Paso, Texas. He appeared for his pre-scheduled CBP-1 appointment. If you recall, that was a program under the Biden administration that allowed people that were entering the United States to schedule an appointment. It was used electronically as an app, as a website or whatever, and they were able to make an appointment to be able to go through the immigration process. At his CB1 appointment, he underwent screenings and provided his biometrics. Rangel was released and scheduled to appear for a hearing on April 4th, 2028, before immigration judge Christopher J. Thielemann. Rangel also applied for temporary protected status in December 2024, which was still being processed for approval at the time of his detention. I want to stop here. I want to underscore how Mr. Rangel's story completely flies in the face of the lies that are being told by the Trump administration to justify their kidnapping, deportation, and removal of people without due cause and in violation of the United States Constitution. Rangel was doing everything that he, quote, was supposed to do. Because we hear this a lot from Republicans, right? Oh, well, they came in here illegally. Well, Mr. Rangel came to the United States, went through the border, went to a port of entry, made an appointment, went to his appointment, had a future court hearing date, and was also applying for temporary protected status. What more was he supposed to be doing? Please, I welcome the Republicans to say what more he was supposed to be doing. Putting aside that now the Trump administration has revoked TPS for Venezuelans and others, so now basically anything that made you, quote, legal in terms of what your status was while you were awaiting to get to a certain point in your citizenship journey, now they've revoked that stuff, right? And so now you can't get asylum or TPS, so now you're deemed illegal, which means it's easier for them to just basically kidnap and deport you. Rangel was working as a barber in Texas, and in November of 2024, he did plead guilty to a Class C misdemeanor because he was riding as a passenger in a car within which drug paraphernalia was located. So let's take a little trip to law school right now. When drug paraphernalia is found in something like a car and there are multiple occupants, unless one of those occupants affirmatively states that it belongs to that person, there's something that's able to tie custody control of that paraphernalia to that person, then everybody goes for a ride, meaning everybody's going to be charged with possession of drug paraphernalia. It sucks, but that's what the law is. And so in this instance, in November of 2024, Rangel was in a car that had drug paraphernalia. He was released from custody. So think about this. Even in his immigration status back in November of 2024, when he made contact with law enforcement, he wasn't taken into custody, right? He was released from custody under an agreement to pay a $492 fine in monthly installments, each of which he paid on time prior to his detention this past March. He made all the payments on time. So now, again, I'm going to underscore this. You have a man that has come to this country through a port of entry. He was going through the process in the immigration system to be able to stay here in the United States. He is found in a vehicle. He is given the opportunity to go home. He was given the chance to be able to rectify the crime in the situation by paying monthly installments for a fine, which he did without failure. Sound like a violent criminal to you that needs to be removed because the country gets safer? Let's keep going. Rangel has no other criminal record and, by all accounts, was a valuable and upstanding member of his community. But then, on March 13th, 2025, on his 27th birthday, ICE detained him in the parking lot of his apartment. Although he presented documentation to the ICE agents reflecting his port of entry information, his temporary status, and his scheduled appointment in 2028, the agents rejected the documentation, took him into custody. Why? Because the ICE agents lied. They lied and said that his tattoos affiliated him with the Venezuelan gang Tren de Aragua, TDA, Tren de Aragua, which, as you guys know, was the basis for Donald Trump doing his executive order under the Alien Enemies Act, right? So TDA gang tattoos is being used falsely to be able to justify rounding up people and summarily deporting them. ICE agents asked him to show all of his tattoos. He complied and he lifted his shirt. The agent said his tattoos indicated an affiliation with TDA, the gang. Rangel immediately denied it, said, no, I work as a barber. I have no connection. But regardless, he was taken into custody. And to date, he has never had the chance to be able to refute that claim, that false claim by ICE that he is affiliated with Tren de Aragua. Rangel tried to make a phone call, was denied. Tried to say he needed to meet with a judge, he was denied. Was given a piece of paper, it was in English. He doesn't speak English, doesn't read English. He wasn't translated into Spanish. They made him sign a piece of paper. He was never given the chance to appear in front of a judge. Remember, we talk about due process, notice, reasonable notice, opportunity to be heard. Not happening here. Rangel was lied to several times by the federal government. He was told he was being deported back to his home country of Venezuela. Well, we all know that never happened. In the end, where did he go? He was sent to El Salvador, where he was shoved into that disgusting prison, CCOT. And he was there. And for more than 5 weeks, the United States government failed to provide Rangel's family with consistent information about where he was located. They initially said to his family that he had been removed to his country of origin, which is El Salvador. But when they were like, no, he's Venezuelan, they're like, oh yeah, okay. I guess eventually, yeah, he was moved to El Salvador. Just goes to show that these assholes didn't know, or maybe they did know and they just didn't care. The claim walks through how the United States and Salvadorian officials were bragging about their circumvention of court orders to be able to bring people like Mr. Rangel back to the United States. And while at CCOT, he endured physical, verbal, and psychological abuse. He was beaten in his chest and stomach by the guards. They used fists and batons. He was taken to an area of the prison that didn't have cameras where they beat him viciously. He was forced to witness the guards severely beating other detainees. He was held with 18 or 19 other Venezuelan detainees in a cell that was barely larger than 10 feet by 10 feet. Most of the days, they stayed within that cell for 24 hours, rarely being allowed to exit that cell. He slept on a metal slat with no cushions or pillows. There were 2 toilets in the cell that were completely open. The cell was only cleaned once a week. He suffers from gastritis, for which he was not provided any type of medication. He was never allowed to speak to his family or any attorney while he was at CCOT. Eventually, on July 18th, about a week ago, Rangel was released in that prisoner swap, where he was then sent to Venezuela, and now he is with his mother in Municipio Baruta, Venezuela, and he is absolutely terrified to return to the United States. People, he was here in the United States going through the immigration process, but now he's so scared to return because he doesn't want to have the same shit happen to him again. This is exactly a quintessential example of how the Trump administration has completely bastardized, perverted, and completely weaponized the immigration system, which admittedly was broken before Trump. It was broken. Trump, Biden, Trump. I mean, look, the immigration system has been broken, but this is not the solution. The things that happened to Mr. Rangel, these are not the solutions that we have to pursue. When asked, the White House's spokesperson said the following. They said that Rangel entered the country illegally in 2023 from Venezuela and is an associate of Tren de Aragua. He was deemed a public safety threat as a confirmed associate of the gang in process for removal. Lies, 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 lies. All lies. Judge Boasberg has also said that based upon the information that's been provided so far, including from that whistleblower, Arez Roveni from the DOJ, or formerly of the DOJ, that is a gentleman that we've covered his whistleblower complaint in great detail here at the Katie Phang News Channel. Judge Boasberg says that he is going to follow up on that whistleblower complaint. And he says, to the extent that they prove to be accurate, those allegations have only strengthened the case for contempt against the Trump administration. Again, a win for the rule of law, meaning, look, of course, Rangel, I don't think it takes a lot to predict. The government's going to deny Rangel's claims. He's going to have to file suit. But you know what? At least there are people like Norm Eisen and Joshua Kolb at Democracy Defenders Fund. I'm so proud to be a part of this organization that are willing to take these cases on and willing to take on the Trump administration, because this is what we have to do. We have to use the existing systems and the existing institutions to be able to achieve justice however we can get there. And for somebody like a barber who came to the United States from Venezuela, who was just trying to make a life here and stay here, he didn't deserve this. And there are hundreds of people whose stories are so similar right now, and we need to uplift their story so people understand understand what they have gone through at the hands of the Trump administration. It has been illegal, unconstitutional. There has been no due process provided that is supposed to be guaranteed under the United States Constitution. If that document means anything to anyone, including Republicans, it needs to have a value and it needs to be respected. And I'm grateful. I'm grateful that actions are being taken and that we're not letting people just, roll over and play dead about this, that we are forcing accountability however we have to do this come hell or high water. And that there are judges like James Boasberg and Paula Zennis that continue to push this forward as well in their own defense of the rule of law. Be mad, be outraged, demand accountability. Democracy Defenders Fund is doing exactly that on behalf of Mr. Never Rangel. His name is very complicated, but you know what? Go and learn it and read about his story and show some support because it would be great. I'll see you on the other side. You want to take a trip down memory lane with me? And it's a good one. I promise. It's the one where convicted felon Donald Trump was found liable for defamation against my dear friend and spectacular human being all the way around, E. Jean Carroll. And you'll remember this verdict. $83.3 million. That's the amount that the orange turd was tagged for as a result of that civil case. And we have always talked about the litigation against Donald Trump. Lately, it's been against the administration, but there was a time when Donald Trump was being sued in his personal capacity for a number of things, when he was indicted and prosecuted in his personal capacity for a number of things. And this case was the whammy, the whopper, the big one, putting aside the successful prosecution by Attorney General Letitia James of the state of New York for, $500 million for civil fraud. This is the one that was the punch a bully in the nose. This is the one that we all personally relished. So why are we taking this trip down memory lane? Well, yeah, it felt good to do so, but also for you here at this channel, the channel that I share with you, my viewers and subscribers. What do I have here? I have a fantastic opinion from the Second Circuit Court of Appeals, Federal Appeals Court in E. Jean's $83.3 million defamation lawsuit. And what have they said to Donald Trump? Pound sand, orange turd. Take a hike. Because everything that you're bitching and complaining about on appeal, tough. It doesn't work with us. So let's get into the details and into the legal weeds of this opinion. It was decided on August 8th of 2025 from arguments that were done on June 24th of 2025. In this opinion, painstakingly written by 3 judges on the Second Circuit Court of Appeals, basically tells Donald Trump, you snooze, you lose. So what happened here? If you'll recall, Donald Trump tried to substitute the federal government back in, frankly, a few years ago when this trial was pending. He tried to substitute the federal government in for himself under this legal concept called the Westfall Act. And we're going to get into that in just a minute, but I want to get you up to speed. So Trump tried to substitute in the DOJ. Then Attorney General Bill Barr said, yeah, we need to be substituted in. Why? Well, because Donald Trump was acting in his official capacity as president when he defamed E. Jean Carroll. And what happened was they ended up withdrawing, as in Trump/DOJ, they ended up withdrawing that certification that the government needed to be substituted in for Donald Trump. The case went to trial. And as she was led by this spectacular attorney, Roberta Kaplan, a jury returned a verdict in the amount of $83.3 million. All right. So after that verdict and on appeal, Donald Trump was asking the appeals court to allow the government to be substituted in for him. Why? He wants the government to have to be in the hot seat for all of this. He, as in Donald Trump, never wants to have accountability for what he does. And so in this instance, he says, oh yeah, you remember that time I tried to do that and then I withdrew it? Well, I'm doing it again. Psych, I'm trying to do it again. And the Second Circuit's like, peace out, brother. That's not going to work. So on June 18th, the court issued an order denying Trump's motion, but this that was just issued just a couple of days ago, this is the actual explanation as to why the court was denying Trump's motion. And quickly, in summary, the order says, the opinion says, we conclude that Trump's motion is statutorily barred by the text of the Westfall Act, that both Trump and the government waived any right to now move for substitution by failing to timely petition the district court, and that in any event, principles of equity warrant denying Trump's belated motion. Now, let's get into a little bit more of the details. Refresher. Back on November 4th of 2019, E. Jean Carroll filed this one count of defamation per se against Donald Trump in a New York state court. She sued Donald Trump in his individual capacity, asserting that the comments that he made about her in June of 2019, while he was president of the United States, that those were defamatory. But she made it clear, E.G. made it clear, that those statements were not being made in the context of him acting as the president of the United States. He may have been having the title or the role at that time, but that the statements he made were in a personal capacity. Then Attorney General Bill Barr, in September of 2020, said, you know what? We are going to file this thing called a certification pursuant to the Westfall Act, wherein we state that Trump was acting within the scope of his employment when he made those defamatory statements. And so we're going to remove the case from New York State Court to a New York federal court, and that we are going to seek to substitute in the United States government as the defendant in E. Jean Carroll's lawsuit. So the case gets removed to federal court. And in federal court, the trial judge says, nope, not going to substitute in the federal government for Donald Trump. Trump immediately appeals, and so the case kind of takes a pause in the trial court level. And the appeals court said, we are not going to decide whether he was acting in his scope of employment when he defamed E. Jean Carroll. We are going to let the trial court tackle this question again. And so the trial court says, okay, then this is what I want. I want any further submission by the United States with respect to the substitution of the United States for Donald Trump to be served and filed no later than July 13th of 2023. On that date, or just a couple of days before, the government notified the district court judge that the Department of Justice is declining to certify that Donald Trump was acting within the scope of his office and employment when he defamed E. Jean Carroll. And so because of that, that certification was gone. So the Westfall Act allows the federal government to be substituted in for a federal employee like Donald Trump if that federal employee is sued for a tort during the course or the scope of his or her employment. It's pretty straightforward, but it requires a certification by the Attorney General or an Attorney General designee to be able to do so. So just to get you caught up to speed, Bill Barr says, yes, Donald Trump was acting in the scope of his employment as president when he defamed E. Jean Carroll. But then the Department of Justice in 2023 says, nope, we're not going to actually do that certification. So they withdrew the certification. So it left Donald Trump on the hook individually. The case goes to trial. In January of 2024, a jury returned a verdict in E. Jean Carroll's favor for the damages amount of $83.3 million. So then he, as in Trump, appeals. And he appeals a myriad things, but one of which was that the trial court erred in not allowing him to be substituted in, and now the appeals court erred in not allowing him to be substituted in, and the appeals court's like, no, not going to happen. So here's the gist of why that's the case. The trial court says the following. If we are going to have the substitution of the federal government for an individual, an employee, as it were, but in this case, it was just Donald Trump in his individual capacity, it has to be done prior to trial. I mean, if you think about it, it makes sense, right? Like, why would we go through the machinations of an entire jury trial, and then on the other end of the jury trial, after the jury has done its duty and a verdict has been rendered, we're then going to say, oh yeah, by the way, we can substitute in the federal government. The reason why that's absurd on its face is, in this instance, if the federal government had been substituted in for Donald Trump, E. Jean Carroll's case would have been dead on arrival. Her case literally would have been dead on arrival. And so that's why the appeals court says your lack of timeliness on this is egregious. And this appeals court slams Donald Trump for it and says, what is the timing of this? How are you doing this now when you knew that you had to be able to do this prior to the beginning of this trial, because the trial went all the way through to the very end. And the the appeals court says here, the before trial language places a timing restriction on both the certification by the Attorney General and the removal of the suit from state court to federal court. Without that certification, there is no removal. And it's undisputed and indisputable that removal must be accomplished before trial. As such, the certification must be made before trial too. Any substitution motion must be made before trial. And in this instance, neither the federal government nor Donald Trump tried to do so. Furthermore, when you invoke the Westfall Act and it actually does go to trial, it's a bench trial. It's not a jury trial. And so once again, E. Jean Carroll went through an entire jury trial. And if the Westfall Act had been appropriately applied, because Donald Trump had timely moved to make sure that the federal government was substituted in for him, then you would have had a bench trial, not a jury trial. I mean, it would have eliminated a wasting of resources here. And like I just said a couple of minutes ago, the Second Circuit Court of Appeals says very clearly on page 14, in other words, the Westfall Act is a substitution and it's in the nature of immunity from a lawsuit. And immunity-related issues, the court has several times instructed, should be decided at the earliest opportunity. In other words, the Westfall Act would have given immunity to Donald Trump to be civilly sued by E. Jean Carroll in this instance for defamatory statements, assuming that they had been made during the course and scope of his employment as president. But because they were not, because he was sued as individual capacity, and because the Department of Justice did not certify that he was acting in the scope of his employment, then Trump was on the hook individually for liability to E. Jean Carroll. And then I just want to kind of fast forward a little bit here and kind of get to this issue of waiver. The Second Circuit Court of Appeals then says, we begin with Trump's waiver. Waiver occurs when a litigant intentionally relinquishes a known right. Trump could have moved to have the Attorney General certify that he was acting in the scope of his employment at the time that he made those defamatory statements. But Trump declined to do so. Indeed, at no time after the remand, meaning it went from the appeals court back to the trial court, did Trump file anything regarding substitution in the district court. By declining to seek such relief, Trump waived his right to now bring this motion. Our law waiver does not permit a party to withdraw an objection in the district court, which is the trial court, and then attempt to reassert it on appeal with the benefit of hindsight. I mean, I really appreciate the ending of this Second Circuit appellate opinion, and I want to share this with you. This is on page 22. The parties have litigated this case extensively for more than 5 years through multiple courts. Liability was determined at the summary judgment stage. The matter then proceeded to a jury trial on the issue of damages, and the jury returned a verdict of $83.3 million in favor of Carroll. After being sworn into office for a second term as president on January 20th, 2025, and throughout the briefing in this appeal, neither Trump nor the government moved for substitution. The practical impact of permitting the movants, plural, meaning Trump and the government, to permit the movant's untimely motion to substitute would be to unwind those 5 years of litigation and a duly rendered jury verdict, and potentially to deprive Carroll of any opportunity to pursue her claims. A successful motion to substitute would have resulted in this matter being governed by the FTCA, the Federal Tort Claims Act. The Federal Tort Claims Act does not waive the sovereign immunity of the United States for torts of defamation. So, if the United States government had been substituted in place of Donald Trump, it means it would have been the failure of E. Jean Carroll's defamation lawsuit. The movement's decision to forego certification until now prevented the district court from considering this case dispositive issue in the first instance ahead of both the summary judgment ruling and the jury trial. And this is great. After several years of litigation at substantial cost to all parties and a significant victory for Carroll, it is simply too late to bring this motion. Fairness and equity dictate that the motion to substitute be denied. End quote. It's a thing of beauty to behold when the rule of law is respected and when judges understand that their jobs are not to be advocates for Donald Trump, But judges have to call balls and strikes as they see them. And when the law and the rules of procedure, including those of appellate procedure, call for Donald Trump to be held to task, and held accountable for being asleep at the switch, for snoozing and losing, then thank gosh for these judges. Now, you and I both know what's next. Donald Trump will bitch and complain and say that these judges should be impeached and that they are rogue judges, renegade judges, liberal judges, etc. And I want to move away from talking about whether or not certain judges are appointees or not, unless it speaks to their qualifications to sit on the bench. But I will spend time to say this. This was a per curiam opinion, meaning all three of these judges, Chin, Merriman, and Khan, all agreed on this outcome. And this outcome is important for E. Jean Carroll. Legally, it sends the message that Donald Trump, in his individual capacity, has defamed a woman who he was found liable of sexually abusing by another jury of his peers. Because remember, it was two separate moments in time for E. Jean Carroll for her litigation. There was the sexual abuse and defamation. There was the defamation. And E. Jean Carroll has won in both instances. And it is important for her to be able to get these victories on appeal, because this means she's one step closer to getting to collect on her $83.3 million and counting, plus interest, for that verdict. Donald Trump is not going to be able to evade accountability in our judicial system forever. These are the moments that we celebrate. These are the victories and wins that we have to make note of. Because in the midst of the insanity of what is going on right now in Trump 2.0, in the midst of the total authoritarian takeover that we're trying to see him do in places like DC, LA, and others, in the midst of the total havoc and destruction he is causing on American working families and the stealing of healthcare from millions of Americans and his kidnapping of people, including United States citizens, off of U.S. soil to take them to third countries and to torture prisons in El Salvador. These are wins. These are legal victories. These are not fictitious things. These are not flights of fancy. These are real legal wins. And right as rain, you're not going to hear about this shit on Fox News, and you're not going to read about this anywhere else, but you're going to hear about it here, because this is your channel. And this is where we learn together. So share this good news far and wide, and let's lift up and celebrate Roberta Kaplan, Robbie Kaplan, the exceptional lawyer that has been leading the charge for my dear friend E. Jean Carroll. And E. Jean, this one's for you. Dr. Marvin Dunn, Professor Emeritus at Florida International University, a veteran of our United States Navy, a Black historian, has filed a lawsuit to stop the DeSantis administration, more specifically the Miami-Dade College Board of Trustees, from transferring land to the Trump Presidential Library Foundation for free. I've covered it here at this channel. I had to speak to Dr. Dunn. I wanted to know why he filed the lawsuit. I wanted to know what was going on. And then I also wanted to explore with him why it's so important for us to get into good trouble. Take a listen. And joining me now, I have the privilege of being able to spend time with Dr. Marvin Dunn. Dr. Dunn, you and I have crossed paths a few times before, but it always is a privilege to be able to learn from you and to just kind of hang out. Thanks for joining me. You brought, I think, something that was so necessary, which is a compelling lawsuit. And I have it in front of me. You brought it against Miami-Dade College, the Board of Trustees, and the individuals serving in their capacity as the Board of Trustees for Miami-Dade College. It's to stop this land transfer, which frankly is just a theft in plain sight, right? In daylight, of valuable land, to give it to the state of Florida's land trust so that Donald Trump, convicted felon Donald Trump, can build a quote unquote presidential library on the premises. I've covered it pretty extensively here at this channel, but I was so inspired when I saw your lawsuit. Talk about why you thought it was so important to bring the lawsuit.
I got mad.
Good.
I thought, they're taking land from our babies. These are our kids, unborn babies. What's the matter with you? Nobody does that. And and I thought,
they're not doing SNAP benefits right now either. So that's a whole other thing too. But
exactly.
Go ahead.
But Katie, I tell you, I would be just as upset if they were trying to do this shit with Obama, with any president. That
Good.
is land for our kids unborn. I don't care if Miami-Dade College has a parking lot for the next 20, 30 years. They have no right to just give it to a politician. So I got angry, frankly, to answer your question. And then I got curious. So how did that happen so fast? They didn't have conversations before, I assume. That would have been illegal. They meet for 3 minutes, one item on the agenda, potential transfer of real estate, and it passes unanimously. How does that happen without people talking to each other before that vote was taken?
It's a
So
mind meld going on where they figured it out.
exactly. And within minutes or within hours, the state announces it's going to Donald Trump for the presidential library. Something, as my grandmother would say, something the milk ain't clean. It doesn't add up. So that's why I brought the lawsuit, Katie.
Well, to get people caught up to speed, it happened on September 23rd of 2025 at a Board of Trustees meeting. And according to the lawsuit and as verified by media reports, the land, which is a incredibly valuable location in downtown Miami, which for those of you that have visited downtown Miami, if you guys know, it's near the Freedom Tower where we did No King's Day 2.0 in Miami. It's near Bayside Park. This 2.6 acre piece of prime real estate, it was literally voted unanimously, as Dr. Dunn just said, given away for free to the state of Florida so the state can give it to the Donald J. Trump Presidential Library Foundation. And as Dr. Dunn noted, the law requires that there's reasonable notice given pursuant to the Sunshine Act. And here's the notice that was given. Are you ready? It said, quote, the purpose or agenda was, quote, at this special board meeting, the District Board of Trustees will discuss potential real estate transactions, end quote. That's it.
Wouldn't that make you want to run out and find out what's going on there? There's just nothing there. It's just air. So that's the basis of our suit, that there was not adequate, reasonable knowledge given to the public so that we could have something about this giveaway. And Kate, I think the reasons that there was not a public notice is that they didn't want people coming in there. Most people in Dade County don't want that land to have been given away. Even folks who support the president in Dade County, most people who responded to a poll who support the president, Republicans, say that land should not have been given away. So it's a painful hurt to our community, and we're going to resist it all the way as far as we can.
Well, and the reason why it really smells, and to use that great saying from your family, that something's rotten. I was going to say something's rotten in that milk, my friend. What ended up happening here was, so the Board of Trustees votes at Miami-Dade College, which is a public college, by the way, people, if you don't know this is a public college, and it serves our community and others outside of our community to provide an education. What it did was this, it then transferred the land to this land trust, and the land trust, Dr. Dunn, is made up of the governor and at least 3 other people, including his attorney general, who I cannot stand, and like just basically DeSantis cronies are on this land trust, and then they're the ones that said we're going to give it over to Trump, right?
Correct. Exactly. And people in Florida should be outraged at that. At that same meeting where they gave away this land to Trump, they charged. Let me get it straight. There was a Republican donor that they paid $83 million for his land, but gave away the land that belonged to Miami-Dade College. So there was a lot of things going on in that meeting beyond just what the Board of Trustees did. We just don't know about. So the reason for the lawsuit is to find out, bring the stuff out into the sunshine. Was that one lot the only lot traded out? Miami-Dade College owns 3 lots there. One of them is huge. And I think that really, really big one right opposite the Miami Arena is the Golden Egg. So we don't know how much of that land, of those 3 lots that Miami-Dade College owns, have been given away, traded away. We hope that the lawsuit will clear up some of those questions.
Yeah, and the Florida Sunshine Act is a law that requires this measure of transparency when places like the Miami-Dade College, a public institution, is operationally doing things and making decisions like this. It's this exact idea. You have to have transparency on it so people understand. And you know what's wild is, because like I said, I covered it here. There have been discussions previously with developers on what to do with that land. It could be used for classrooms. It could be used for, frankly, commercial purposes, but it would at least make money for the
To
college. It would at
benefit,
least bring in
exactly,
money, right?
exactly. And that's not
And
going to
in
happen. They're gonna build. They've been very clear. They're going to build an iconic structure on Biscayne Boulevard on that property. They've talked about condos. They've talked about bringing the president's plane once he retires and gives it up, having an airplane sitting on Biscayne. I'm serious. They're going to put that big thing on Biscayne
Dr.
Boulevard once the
Dunn
president stops using it. It belongs to the Trump Library. That gift from Carter belongs to
from
the
Qatar. Mhm.
library and will come eventually to Biscayne Boulevard.
So, you know what's outrageous? You want to talk about a colossal waste of damn time? Here we go. So, you filed this lawsuit. And by the way, shout out to Andres Rivera, who I love at Rivera Mestre, one of your lawyers, and Richard Brodsky, also
Yes,
another
they're
great
great.
lawyer.
Pro
Shout
bono,
out
pro
to my
bono.
local lawyers. A big
Yeah.
fan of both those gentlemen. So, y'all go to court and you get Judge Mavel Ruiz. And Judge Ruiz actually grants a temporary injunction. She basically says,
Yes.
pump the brakes. You can't actually satisfy this land transfer yet. You got to fix this problem because I believe that Dr. Dunn's lawsuit is well taken that you didn't give reasonable notice. Instead, and by the way, Judge Ruiz actually says to the college, hey, y'all could kind of cure this defect by actually renoticing this public hearing, making sure you're appropriately following the Sunshine Law, and redo it. But instead, they're like, no, we're just going to appeal it and make the third District Court of Appeal, which is stacked with Governor DeSantis appointees. We're going to make them order you, Judge, to be able to be declared wrong, and we're going to make sure that this moves forward. I mean, it blows my mind how wasteful this is when they could just fix it, unless, to your point, Dr. Dunn, there's something nefarious afoot.
There's more going on. It's not just this one thing. So we will find out. If the court agrees, we will start doing the process of bringing folks in and talking to them under oath and asking who knew what, when, why, and whatever. The truth will come out. The truth, let me just say this about the DeSantis stacked court, appellate court,
Yeah.
and Supreme Court, for that matter.
Yes.
This may sound weird from an 85-year-old man, but I still have trust in the courts. I really do believe that if our country is saved, it's going to be just judges who will say Republican, Democrat, whoever. That's wrong. That's not lawful. And I think most judges in our community and our country are faithful to the law. I maintain that very strongly.
And I appreciate that vote of confidence, Dr. Dunn, because I too believe in the rule of law. And I do believe that the courts, the judicial branch, is going to have to save us at this point. We have an ineffective legislature that doesn't do anything in Congress and an executive branch that's overreaching. And so we have to count on the courts to stop this. And listen, I'm not surprised. I am surprised that you're 85 because you certainly don't look 85. But Dr. Dunn, I'm not surprised that you would bring this lawsuit. Part of the reason why you and I have crossed paths before is not only are we both Floridians and South Floridians at that, but you've really been at the epicenter of racial justice, or perhaps lack thereof, especially in Florida. Your roots go deep and strong and long in this state. You founded the Miami Racial Center for Justice. You have a PhD in psychology, your bachelor's from Morehouse College. Congratulations on being the recipient of the 2025 Benny Service
Thank you for
Award.
mentioning it. Thank
And Dr. Dunn, I want to take the privilege right now of spending some time with you to talk about, though. And by the way, thank you also for your service as a naval officer. I appreciate your service, sir. I want to talk about why it is so important for us to do things like you're doing, standing up at a time when all they're trying to do on the other side is stoke fear and to try to make us feel downtrodden, where we don't feel empowered to be able to do these types of things.
Katie, once you decide, there's nothing they can take away from me. What are you going to do with me? There's nothing they can take away from me. So stop me from speaking. Stop me from teaching. There's nothing you can take away from me. And once you have that sense of freedom, you can say and do whatever you wish. And I understand people have obligations. I understand people have mortgages and kids in college and all that. I'm retired. I do have that kind of flexibility. But across the board, it's when people say, okay, make me. Whatever's at risk, I'm going to do the right thing. And I think what we see now with all these folks turning out for No King's Day and all of that, there's a lot of Americans that are saying, okay, make me. Make me.
You have written books, you have films, you have documentaries, you've done Black history tours. I mean, and again, like I said, your family roots go deep and long in this community and in the state. Your thoughts about the whitewashing, sir, of our history, not only here in Florida through the war on culture, the quote, war on woke by DeSantis and his administration, the book bans, the attempts to rewrite what our history is, to whitewash it so that future generations don't know the truth about how we got where we are.
Well, now we're going to have a Florida Black History Museum in St. Augustine. I will never set foot in it. You're going to have a Black History Museum that DeSantis tells the Black folks what goes into it. Huh. Why would a Black person go into a Black History Museum where white people picked out what could be in it? So I'm very, very disappointed that that's going to happen. It's crumbs to the Black community, but I don't need to go to a Florida State Black History Museum to learn the benefits of slavery. And that's the kind of stuff they're going to be putting out in this museum. Let me just say this, Katie, because my work has dealt with the most painful parts of Florida history, lynchings. I've gone to almost every place in Florida where these kinds of horrific things happened. And I've been doing that now for 20 years. I won't go into details, but almost every place I've been and studying these events, I've found at least one or two white people who did the right thing. One or two white heroes who said, no, the mob can't come in here. Who said, I know these people. They work for me. Get out of here. You find that even in the worst of historical horrific incidents, I've found, except in one incident, white people, a few, who came forward and tried to protect Black people. Most white folks just stayed silent. They knew who did what, when, but it was their uncles and brothers and dads out there doing this stuff. So the kind of racial violence that we have experienced in our country has happened because most white people were offended by it, frankly, but remained silent. And thank God a few did the right thing in those terrible moments. Not nearly enough, but a few.
You have to draw some comfort, though, Dr. Dunn, in the imagery that we are seeing, albeit we see the horrific stuff that's happening with our immigrants across the United States. But we also see an uprising now. We see people using their phones, their cameras to document these atrocities, but that's power in and of itself, right? And then we also see people stepping up and trying to intervene when ICE and other federal officers, agents are doing things illegally. They are masked. They have no identifiable information. They are doing these things sometimes in the dead of night, like on the south side of Chicago, rappelling out of Blackhawk, snipers banging down doors, kicking down doors in a building that was predominantly Black and brown. I mean, we see people, though, outraged. Through your insight as a historian, are we at some type of critical mass now? Are we at some inflection point where the people are going to take power back into their hands and say that this is enough?
Yes. I think we're past that point. I think that pendulum is swinging back the other way. Even as we speak, I think more and more Americans are coming to realize that this is not us, armed troops in American cities. This is not us. The very image of that around the world should be offensive to Americans. This is not us. We don't need the army in our communities enforcing the law. So I think that in and of itself, when people saw this happening, I think many folks said, okay, this is not America. The other thing is when folks saw people who have no criminal record, no threat to America being rounded up, having been here for 30 years, working, paying taxes and all that, being swept up and taken away in the middle of the night, children being separated. This is not America. So, I spent 7 years, as you mentioned, as a naval officer protecting my country. And I know that we're better than this. Now, what they try to do with those of us who have these kinds of feelings is they try to dismiss us as being woke professors or lunatics on the left or what have you. But Katie, most of the folks I'm talking to and seeing are just people who are saying, I'm an American citizen, I love my country, and this is enough.
You are a professor emeritus at Florida International University, FIU. There is a war that is being declared on DEI at colleges and universities, especially those that are not private, even private ones. We're seeing some capitulation, some bending of the knee from major institutions of learning. And we're also seeing a huge infiltration, for example, sir, like in Texas, where they're requiring the 10 Commandments to be posted on the wall of every public
in Oklahoma,
classroom. Your thoughts about how this truly is a march towards an autocratic state or an authoritarian regime where there's only one person who's controlling content and material and education and knowledge.
Right. So have you not heard about my Black History Learning Tree at FIU? My Florida Black History Learning Tree at FIU? You know, I don't know how much time we have, but you asked the question.
Please go ahead. No, of course. Please go ahead.
Every Black community I know of has a tree. Everyone. It's where the men hang out after work. Women are doing stuff, getting ready for the next day, but the men hang around and tell lies and joke and play the dozen and pass on history. Every Black community has that. A lot of them more than one tree. So I was out at FIU one day returning some artifacts at the library, and I thought FIU needs a Black History Learning Tree. It's about 6 months ago, where I can teach anyone else who wishes to as well, Black history as it was. So I simply picked the beautiful tree right outside of the library, started setting up tables, chairs, and people just come, and it just blew up. The last time I had about 300 people out there for the last Black History Learning Tree. I didn't ask permission, Katie. I didn't ask anybody if I could teach history at FIU where I taught 36 years. I got to ask someone. I just started doing it. And people started coming, and we've been having the police stay away. They keep, but that's the kind of thing we have to do civilly within the law, but get in the way. Like John Lewis said, get in the way when they're trying to stop you from doing something and you know it's wrong. Just find a non-violent way to get in the way. And that's what we did with the Black History Learning Tree, and we'll continue to bring scholars and have programs out there and have fun just saying, no, we will not succumb to that kind of oppression.
Dr. Dunn, you're 85 years old. You have a beautiful wife who I jokingly say is the boss in your house. I know Andrea is, but you don't have to do this, right? You could just be retired, take some trips, enjoy your well-earned quiet time, a time of peace. Why is it so important for you to continue to be engaged and to be active in the activism that you're endorsing right now?
I have 7 kids and 7 grandkids. And I don't like what's happening. I don't like what's coming. And I can't afford to not be active. And those of us who are in our 80s and beyond who know history, who know the truth, need to come forward and teach our young people how to work through this. America's been through crises like this before, and it's up to those of us who are elders. And to me, anybody under 60 years old, you're a child of me. Those of us who are elders need to say to you youngins, here's how we did it before. Here's how folks did it before us. Here's how you must do it. And I think that's the path forward. And I think young people come forward and do that for us.
Dr. Marvin Dunn, as I said at the very beginning of our time together, it is a privilege to be able to learn from you. I'm grateful for you taking the laboring oar always to make us better people, to have us have a better understanding of how history is such a critical part of who we are today. And my hat off to you, sir, for this lawsuit. I think it's a necessary thing, and I think it's a version of good trouble, sir. So I appreciate it. Thank you for being with me.
Thank you so much. My pleasure.
It's good to see you.